I want to do a quick overview and discussion of Raleigh versus Performance Plumbing and Heating. It's an interesting case in negligence. We're talking about the duty of care and whether the risk of harm was foreseeable in this instance. And the case is interesting because it's got some facts that I think are relatable and are relevant to all sorts of businesses. And what's happened here is we have a plumbing company that hired an employee, Mr. Weiss. And Mr. Weiss, when he filled out his job application, he said he had a clean driving record. And the plumbing company decided not to do a background check on him. So but the plumbing company does give him one thing. They give him a roof rack to carry. He's using his own car, but they give him a roof rack to carry plumbing parts and pipes and equipment. So Weiss is driving between jobs, driving to and from work, and on the way to work one day, he gets into a car accident, which he causes and seriously injures the people in the other car. So, like we've talked about before, lawsuits always follow the money, and while you might sue Mr. Weiss as an individual, he has much less money and a much smaller liability umbrella than Raleigh Performance Plumbing and Heating. So you're following the money, you're suing the company, and you find out that they did not do a background check, and that Mr. Weiss had this in his reckless driving charge in his background, and they found that while it wasn't a company vehicle, it was a personal vehicle which had a company component, namely the roof rack, installed on it. And so they are trying to allege that Raleigh Performance Plumbing and Heating was negligent for not doing a background check, and that Mr. Weitz's driving was in the course of business because he had the roof rack and he was, expected to get to jobs. So is this within, we talked about that sphere of liability, the sphere of negligence. Is this foreseeable within the sphere that Raleigh Performance Plumbing and Heating needs to keep in mind? And we're not sure. I mean, there's some good arguments again on both sides. I mean, the argument for those who are injured is that if the plumbing company would have done this background check, they would have discovered this, and they might not have allowed him to drive. They might not have let him. They might not have hired him to begin with because they knew that driving was part of the requirements, and they're alleging that him having this roof rack then puts it into the scope of business. On the other side, Mr. Weiss, there are a lot of people who have reckless driving records, but that doesn't mean they can't be hired, right? It doesn't mean they can't have a job because they have to get to work. Everyone has to get to work. So we generally don't say that coming to work, just going to and from your place of business is in the course of employment, right? So because Raleigh Plumbing and these jobs are in different locations, does that make it in the course of employment? Well, probably not. Even though you do have to get to specific sites for your job, you are not being paid for that time. You still have to get to work no matter where it is. And so generally we look at driving specific places as not being within the course of business. Does having the roof rack on suddenly make this within the course of business? Again, probably not. Just because you have essentially a tool installed on your vehicle temporarily to help you with the job does not mean that you're suddenly always within the course of business when you're driving different places. And then, finally, is it foreseeable that they would have caused that Mr. Weiss would have gotten into an accident and caused harm when they hired him, and they omitted looking at the background check? Again, yes and no. Would they have discovered might they have limited his driving? Perhaps. We don't know. We don't know if that would have affected them. But again, we're not in the course of business here coming to and from work. I think if this would have been, if driving would have been part of his job, he's a trucker, for instance, or his job, or even if this happened going between two different sites where he was getting paid at the time, or on the same job, but you have to go to different locations as part of that job, then I think there's a much stronger argument that they were negligent in not doing the background check. But in this situation, you're really looking at this person's coming to and from work. The roof rack doesn't matter, and so it's not foreseeable that if they have a charge in their background, an issue in their background, in their driving record, that they could cause some kind of injury coming to and from work. So in this case, we are not seeing negligence here, but if the facts changed a little bit, you could imagine how it would suddenly be within the foreseeable scope of negligence.